obviously I'm sure you're very interested to hear what's happening with this case that came through earlier this year, which seems to throw a few sort of spanners in the works of Part 7 transfers, or does it? That's what we'll learn about. But obviously there's some very serious issues raised by the court that haven't been considered by the other parties involved in the transfer. But I won't take too much steam away from the presentation, but delighted that Caroline Burton and Rebecca Huggins from, where are you? Are here to present on this subject. So, I mean, many people know Caroline, who's been a partner there for a lot of years, 20 years experience in the industry as a whole. I've worked with Caroline on Part 7 transfer myself at R&Q very effectively. And over the years, she's been very much involved in transfers and restructuring, and also spent some time overseas in Bahrain for part of that learning and development.
Yes.
But came back.
I came back. Couldn't stay away. No.
Couldn't stay away. Anyway, over to Caroline and Rebecca, and I'll try and keep my questions to them.
Yes, and on that note, we're very happy to take questions and points as we go through, because I expect a lot of people in the room have got some thoughts and experiences already. We're just going to start by going through the background of the case, and then also looking just at some of the general principles and Part 7s before we go into Snowden's judgment in this case. So I appreciate for some people in the room that will be perhaps a little bit boring for them, but we've got a very mixed audience, and we have to ensure that we meet our CPD objectives. So with that, I'll hand over to Rebecca first of all, who's just going to walk through the background to this case and how we got to Part 7.
So we're just going to look for a minute at who the parties were and what they were trying to achieve with their Part 7 transfer. So the parties were Prudential Assurance Company Limited, PAC, which is part of the M&G Prudential Group, part of Prudential Group PLC, and according to their 2018 financial statements, had assets of over 508 billion. So in Lord Snowden's words, they are a very large group indeed. PAC has been in existence since 1848, so it has a very long and a very strong reputation for long-term insurance, both in the UK and internationally. On the other side, Rothesay Life PLC was originally established in 2007 by the Goldman Sachs Group, and the purpose of that was to conduct business as a specialist provider of annuities. It's now owned by Blackstone Group, US Private Equity, GIC Private Limited, Singaporean Sovereign Wealth Fund, and the Massachusetts Mutual Life Insurance Company. So some really big names on that side as well. So, as you'll be aware, a demerger was announced between M&G Prudential and the Prudential Group, and that's now been completed. And so they were separating M&G Prudential out and they were focusing on the UK and the European mature market. And the new Prudential was focusing on the rapid growth that was taking place in the Asian market. And to help move this merger along, they decided that PAC should reduce some of their regulatory capital requirements, and in order to do that, they were looking at shedding some of their long-tail business. So some of the long-tail business that they decided to get rid of was some of PAC's annuity policies. These placed a significant burden on their regulatory capital requirements because the policyholders are locked into a contract over many years and you can't get out once you've started. So they were sitting there with that liability and in quite an inflexible situation. So after reaching agreement with Rothesay, they looked at a Part 7 transfer to move the long-term annuity policies over from PAC to Rothesay.
Mm-hmm. Which one is it? Oh, so we're going to go. Yeah. Okay, so I'm assuming everyone in the room is familiar with the concept of a Part 7, but just to recap for those who may not be, what it does. So, as a matter of English law, a party to a contract can generally only transfer the rights and obligations under that contract with consent of the original contracting parties. What Part 7 allows is a statutory mechanism where you can transfer a contract without having to obtain the consent of the original contracting party, in this case the policyholder, because instead you've got a court-sanctioned process which facilitates the transfer. It's not new. It didn't come in VISMA in 2001. We've had provisions in the English insurance legislation for a number of years. We've seen a spike in Part 7 transfers over the last year, largely due to Brexit, but generally we would see around 15 or so a year. So pretty common bread and butter for those of us in the industry. Who are the core parties in the Part 7? We've got the parties, obviously the commercial parties, but we've also got the independent expert and the regulators. And we'll just touch on those very briefly because their role comes into play in this judgment. So the independent expert, generally an actuary who is responsible for preparing a scheme report which is submitted to the court. He's independent and his duty is to the court, and his duty is to opine on the impact of the transfer on both the policyholders of the transferor as well as those of the transferee. In essence, he's ensuring that the insurer has enough assets at their disposal to protect policyholders post-transfer. The regulators, the lead regulator is the PRA, but the FCA also has an input, of course. The PRA's considerations, capital, potential risk by the transfer, the purpose of the scheme, impact on policyholders, and the FCA will generally feed into the process via the PRA, and each regulator will also submit a report to the court. In terms of the process itself, we'll have a directions hearing, first of all before the court, following which there'll be a notification process to impacted policyholders, all done in accordance with the court. There'll be a period of, let's say, 8 weeks or thereabouts when the parties can receive objections from policyholders, again very relevant in this particular case. And then we come to the final court hearing, which is when the court sanctions this scheme, and that is in essence the court order that says this transfer or the transfer of this book of business is now effective, subject to whatever conditions the court may wish to apply. In this particular case, the parties went through the process. The independent expert gave his report, the regulators scrutinised the transfer, they had their directions hearing, made their notifications, and in that period they received a significant number of objections from policyholders, and it was marked out by Snowden in the judgment that it was an unusual number of objections. Now, he did go through those objections and knocked off quite a few of them as being irrelevant to the court's consideration, but there were still a significant number that did merit further consideration by the court, and there were also a number of policyholders who turned up in person at the final court hearing. I have some comments on that, which I will come to later as well, but that's the factual background as we have it. So we're going in now to think about and look at Snowden's judgment, and it's quite an unwieldy judgment for those who've managed to wade their way through it. But there are some principles that he agreed, at least in theory, that have not changed and that are common and accepted for all parts of, or all types of Part 7s. So let's just look at some of those in turn. So the Part 7 transfer mechanism is available for all types of insurance business. There is no rule or principle which says, for example, that it's not available for annuity business. It's available for all types of business. The court is the ultimate arbiter. That's enshrined in the legislation in any event, but what the courts were pointing out, and what Snowden has accepted, is that it is the court's duty to consider whether in all circumstances of the case it is appropriate for the court to sanction the scheme. Obviously it will have heard from policyholders, from the independent expert, from the regulators, but ultimately it is for the decision of the court.
And he emphasised very much in his judgment that his discretion was one of real importance, and that he wasn't there simply to rubber stamp something that had been looked at by the regulators and by the independent expert. He saw himself as having a slightly separate role from that, and one in which he was able to take into consideration things which perhaps hadn't been looked at in detail by the independent expert as well. And he referred to the phrase used by Lord Briggs in another case, Pearl Assurance, that the court's discretion should not be exercised in any way by way of rubber stamp. Although he did come back to another case, the London Life Association, which sets out the way in which, in which Lord Hoffman set out the way in which the court should use its discretion. And one of the points raised there was that it must be exercised with due recognition to the commercial judgment of the directors. And I think that's quite important here, because you've got some very able directors in those organisations who have come to a decision to pursue this transfer for sound commercial objectives, and yet the court still felt uncomfortable with sanctioning that.
Yeah, so we also, when we're thinking about the exercise of the court's discretion and whether or not it is fettered or unfettered, the court, and he did agree, said we will still pay close attention to the views of the independent expert and the regulators. But that's not all that the court will look at. And in the round, the court needs to consider whether or not the scheme as a whole is fair. Still agreed as a principle that the test is looking at the security and reasonable expectations of policyholders. There is no policyholder veto. So this comes back to this notion of consent. The whole point of having the legislation is that this can take place without consent of individual policyholders. And in fact, in this case, and in previous cases, we've seen policyholders come to court and say, well, I want to just say no. Everyone else can go across, but I don't want to be part of this. And the court said, no, that's not how it works. We make the decision. And then finally, the role of the regulators. The court does not dispute the way that the regulators review and investigate and assess their views of the transfer. And these days, they didn't always, but these days they do always submit their report to the court as well, and occasionally are represented by counsel in their own right, again, as they were in this case, where it's a complex or significant transfer. So just picking up on that point, on the court's powers, Snowden said the court's discretion is not constrained by the same actuarial factors which guide the IE and the statute-based mandate of the regulators, in other words, the regulators' statutory objectives. So the court is saying, we can look at whatever we want, and if we don't like it, we just get to say no. Where does that leave the rest of us when we're doing our transfers and we're looking at transfers and how to manage them? Now, if you wade your way through the judgment, dotted through it, you see Snowden comparing the transferor and the transferee in this case. This is relevant particularly to this sector as well, because we quite frequently have smaller run-off providers buying books of business from very large insurers who are exiting that line of business, or who are restructuring for capital reasons, or any number of reasons. What were the particular distinctions that Snowden was looking at between the two? So we look at Prudential's very long history. What year did you say? 1848 or something? Yeah. And Rothsay, 2007. Large entity, relatively small entity, member of a very large insurance group. Rothsay is not a member of a large insurance group. Very important, strong likelihood of parental support when you're sitting with Prudential, against what he considered to be relative uncertainty of parental support if you are in Rothsay. And some factors which he agreed, or agreed with the IE, were broadly the same as between transferor and transferee. So when we come then to testing these two parties and how he was applying his exercise of his discretion in this particular case, what were the factors that he drew out in his judgment as relevant factors for the court's consideration in this case? So the first one is the one that I think everyone will immediately jump on, and I have had people say to me, well, this judgment was just about annuity business and it doesn't apply to anything else, so we don't need to worry. And I think the fact that there are quite a few of you in this room suggests that the market is very well aware that this is not something that we can say with any certainty is relevant only to annuity business. There are particular distinctions in annuity business, clearly, and Snowden did in a number of places in his judgment emphasize that the particular nature of annuity business was a factor for him in this case, and it was leading his thinking in a particular way. And those factors took him into the fact that the policyholders were saying, well, we are locked in to this, to the PRU. We chose the PRU, we are locked in, we can't get rid of our annuity, we can't take it anywhere else. We chose the provider mindful of the fact that we were going to be locked in. And clearly that's not the case with other types of business. So he did draw that distinction. The next factor he looked at was policyholder expectations. Now, he did agree that in this case, policyholders didn't have a reasonable expectation that the Prudential wouldn't transfer their policy. And that's quite important, because one of the tests that the court and the IE and the regulators look at are what were the policyholders' reasonable expectations. So whilst he said that, what I found quite interesting was that he seemed to spend some considerable time going through the literature as if he were seeking to find something that he could say they did have a reasonable expectation that their policies wouldn't be transferred, and he didn't find it. Now, he wouldn't have found it because it wouldn't have been in anybody's contemplation that they needed to put an extra paragraph in to tell people that, by the way, we have a statutory right which, subject to court approval, allows us to transfer your policy to a third party. But he looked for it, and that leaves us in an interesting position with policy documentation for policyholders going forward. The other thing that he also looked at, and this is again I think of particular interest to people in this room, is his assessment of Solvency II and the SCR metrics and the availability or not of parental support as between the PRU and Rothsay. Now, Solvency II was set up to ensure that there was a robust capital framework in place so that the liabilities to policyholders could be met for the lifetime of those liabilities. And whilst group support is a relevant consideration for regulators, and we do have group solvency framework in place also, what Snowden did here was essentially say that the SCR metrics on their own were insufficient. And even though the independent expert had, both in his initial report and in his supplemental report, concluded that the SCR metrics were equally favourable for both transferor and transferee, and in fact I think he said that they were slightly better for Rothsay, Snowden said, well, that's not enough. Now, we could say that he was saying, oh, well, that's because this book is going to run on for quite some time. But there are lots of lines of business where the book runs on for quite some time. And in this case, he then was saying, well, the SCR assessment's not enough. I'm looking at what would happen if the inevitable happened and who's going to put the extra capital in. And I think that it's more likely that Prudential will put capital in than Rothsay. Now, in that, I have to say I really do disagree with his conclusion. I disagree with the basis of his assessment and his decision to look at group support and put so much emphasis on it. But also, Rothsay is owned by Blackstone, GIC, and a very large US insurer. And to suggest that those three shareholders would be in a position to step back and let Rothsay go under, I find astonishing. I don't believe that any one of the three of them would be in a position to do so. They are all approved controllers. They all have their own reputations to consider. And I don't see that they're in any different position in that respect than the Prudential. But Snowden disagreed. And so that's where we are. That leads us also into his assessment on the age and reputation of both parties. And what was, I think, somewhat prescient was that about 6 weeks later,
Yes.
the Pru got levied with a rather hefty fine for mis-selling annuities.
Over a long period of time, not an isolated incident.
So reputation can be here today, gone tomorrow, shall we say? Yes, and I'm sure Rothsay may have its day in time as well. But it was perhaps an unhappy coincidence that the focus was put on the Prudential's reputation. The other factor that he drew on, which again is also relevant for this industry, was the commercial objectives of the parties. Now, we already said at the beginning, it's an agreed principle that the court doesn't dictate the commercial objectives of the parties, and in fact it exercises its discretion having regard to the fact that the parties can have their own commercial objectives and decide the best way to achieve those. In this case, Part 7, with an LPT, which I will come to. But he said that the appropriate balance has to be struck. So we've suddenly seen the commercial objectives test narrow slightly, I think. And it's for the commercial parties to satisfy the court that it's appropriate to sanction. Now that, I think, also evidences a slight shift in burden onto the commercial parties to justify why a Part 7 is the right and appropriate solution, where previously court wasn't concerning itself with why they'd chosen the Part 7. Now, the regulator certainly will concern itself with whether or not the parties have chosen an appropriate solution, and in fact you'll often see the regulator say, well, what other solutions have you looked at in addition to or other than a Part 7, but not the court. The other thing that he drew in this, when looking at the commercial objectives, was the fact that they'd put in place their LPT, pretty common structure. But in doing so, they hadn't put in any unwind provisions, because no one had actually contemplated that the transfer might actually not be approved in its entirety. So the parties, in having their LPT with their claims handling agreement already in place, he said, well, you've already achieved your commercial objective, haven't you? So you don't need a Part 7. And I don't think they've had any answer to that, because they hadn't put an unwind provision into the LPT. That perhaps also goes back to the point that Rebecca made at the beginning, where he was saying, and very much emphasised, this process is not a rubber stamp by the court. We, the court, will look at it and we will make the decision. And the fact that the parties perhaps hadn't put an unwind provision into their LPT perhaps evidences that we'd all become a little too complacent, and in fact we were all assuming that it was a bit of a rubber stamp, because if the IE said fine and the PRA said fine, well, you know, you trot along, you do your notifications and you get your order. And I think maybe Snowden was making a point. So thinking about those key points that he did draw out and perhaps distinguish in this case, or the messages that he was giving to the market and also to the regulators, because regardless of whether he said or implied or not that the regulators in the IE had done their job, it is certainly clear that the PRA has taken some messages away, and we all want to be sure that the next time we're going in front of the court, whether it be Snowden or another judge, that we've thought about some of the points that he made. So, is this in this slide or the next one?
Yeah.
Yes, it is. So, the one I just touched on, consider the legal rights and obligations of the Part 7s not sanctioned. So, if the court just says no, what are the parties going to do? If you've put an LPT in place, are you going to unwind it? Looking at your policy literature, now clearly that's not going to be something that you're going to do for a book of annuity business that was written way back when. But going forward, if the court is making the point that policyholders, particularly of certain types of policyholders or policies, could have a reasonable expectation that their policy wouldn't ever be transferred from an Aviva to someone they don't know, perhaps there does need to be a footnote somewhere in the wording that makes clear that that statutory mechanism is there. I don't think it's particularly effective. I think in a world where the FCA is saying tell policyholders what they need to know and focus them on the important things, I don't think the statutory right to Part 7 is necessarily going to be at the top of the list, but perhaps for certain types of business it does need to be. And can the parties, and this goes to the commercial objectives point, can you demonstrate that you've considered alternate structures? Now that would be something that would go into the witness statements or similar, explaining, or perhaps in a bit more detail, how the parties arrived at a Part 7 as an appropriate solution for the particular commercial objectives that they were seeking. Other things to think about in your documents, and some of these I think we will find being addressed in the IE's report also. And certainly anecdotally I've heard of some feedback already coming from the regulators to independent experts on some of these points. Look at the likelihood or not of group capital support. Should the IE be thinking about that and providing some sort of commentary, or at least distinguishing it and saying why it doesn't need to be a major factor in this particular case? Distinguishing the particular book of business from the type of annuity policies that were in play here. As I said, we don't know how widely the courts going forward are going to apply some of the principles or points that Snowden was discussing. If we're lucky, they will continue to distinguish it and narrow the effect of the judgment, but we're a little bit too early in the day yet, so we have to be prepared.
And you can see for something like employer's liability, for example,
yes,
that would be a place where you might take the same considerations.
Yeah, because bearing in mind, we're not just from a regulatory perspective looking at the direct policyholder, we're looking at the beneficiaries. And so that's what turns your policy from something that could short tail into a much longer tail.
Although in fairness, the beneficiaries in the help.
Well, they don't know. They're on.
They're the decision to buy the policy
in the first place. No. Strength of policyholder opposition. Now, I touched on this earlier, and this perhaps also goes to the rubber stamping process. In my experience and in my view, and we've done this a lot on schemes of arrangement, which aren't so common now, but objections and schemes of arrangement and dealing with objectors was something that had to be handled with kid gloves. And I was not involved in this case, so I don't know, but I do wonder if the way that those objecting policyholders were treated was with perhaps a degree of, with a lack of care and attention, perhaps is a better way to put it, such that it meant that when they appeared at court, their voices were perhaps more angry and more forceful than perhaps they might have been had the parties actually engaged at a practical level and tried to evidence to those policyholders that in fact life was going to go on for them much as normal. So in the event of such objections, the real aim should be, much as it would have been with the scheme of arrangement dealing with commercial parties, try to make them go away, and you appease your objectors and you give them whatever information they need to get them comfortable. And market reputations, again, Snowden made very clear that, and I think it was in response to a statement from Martin Moore, who was acting for the Pru, that he was not saying or doing anything in his view that stopped new entrants coming into the market. But if you look at how he drew the distinction between the Pru and Rothsay, you could see why that would be a reasonable conclusion to draw from what he was saying. And so that's something else I think that certainly the regulators in the IE will need to address with the parties in the documentation that they're submitting for the Part 7. So what's next?
Well, the decision is being appealed, but that won't be heard until spring next year, which actually is coming rapidly upon us anyway. So they're appealing on the basis that there are material errors of law, and it will be interesting to see what happens with that.
Yeah, so and I think from a purely legal perspective, that's interesting and challenging, because the legislation, it is ultimately for the court, and it is the court's discretion. So you can't argue easily that the court hasn't exercised its discretion in a proper fashion. So they've identified some material errors of law.
But it's a very detailed. I mean, it's a very detailed judgment to appeal. So
yes, yeah. Watch this space.
Yes, and then since Prudential and Rosset, there have been 3 Part 7 judgments or pre-directions hearings. And the first was an intergroup transfer, so the court sanctioned the transfer of Domestic and General PLC to Domestic and General Europe. So that was really EU and EEA business being transferred from the UK insurer to a German subsidiary. So that was really a Brexit-related transaction. So that was, and was slightly different because the business was remaining in the same group. And then there was an AXA transfer. The courts made pre-directions. So that's a scheme to transfer UK insurance business from German and French companies to an Irish company, and that's due to take place at the end of this month. And that doesn't currently require approval, but it would do if the UK leaves the EU under a hard Brexit. So again, that's a slightly different situation. And then we've got the Canada Life case that's mentioned up there. And there isn't a published transcript for that case, but from what we've read so far, we understand that counsel there was able to distinguish that case from the Prudential case, partly because it related to unit-linked policies which policyholders were permitted to transfer, so you didn't have the sort of lopsided nature that you had in the Prudential case. And there was no question that the transferor had already achieved its commercial aims through another path, as with the LPT here. And the capital policies of the 2 companies were found to be equally strong, and the court found there was no adverse impact on policyholders or any unfairness created. And there was no suggestion in, I understand, from that judge that the policyholder's initial choice of provider is a factor to which the court should pay attention. As I say, we haven't seen the transcript of the judgment in that. That's what we've heard.
But what I think comes out of that is that there were a number of limbs of the Snowden judgment which were addressed and then distinguished in that case. So you can see that if that is the road that people are going to be travelling down, we do need to take account of some of these factors in the documents and the submissions to the court, and it's for the parties and their advisors to indicate and guide the court as to all the reasons why we don't need to track what Snowden said in the Prudential and Rosset case.
Question. So, I mean, we're very happy to take questions, but also we'd really like to hear, we know there's a lot of experience in the room, so be very interested in other people's impressions and thoughts about the case and the way forward.
Yeah, I mean, your observation about hopefully not having to track against Snowden's comments, which item is probably pretty important, isn't it? It's kind of slightly worrying that they've already decided to track against them in this one, because that sort of gives credence and strength to the arguments that he's using. And the worry for the legacy market generally would be just on this issue of relative strength.
Yes. Yes.
You come away from the principle of is the acquirer, fit and proper and able financially to handle the risk that future things might bring, as distinct from simply is his balance sheet the same as the guy who's transferring? Because if so, that pretty much closes the market, doesn't it?
Yes, exactly.
Just on that alone, forget everything else.
And that was when you read the judgment.
Not just legacy either.
Yeah, yes, for all sorts. Yeah, and I think that was the point that Martin Moore had tried to make to him in court, and he responded directly on that point. Said, "Well, I'm not doing anything that would bar new entrants," but it sort of takes you to, well, well, what are you saying then? Because how are you ever going to jump the hurdle if you're putting such importance on it? Yeah.
So presume, I mean, it feels, the thing that seems odd is he, instead of him saying, oh, the new sort of new provider or where the balance sheet's got to reside on has to meet a certain hurdle, it would change the hurdle depending on who it's coming from.
Yeah.
So it's not so much a question of how strong is the counterparty that's taking on, but more of what's the difference between the two.
Yes.
Yeah. And then you've just thrown a coach and horses through Solvency II. Because what have we got SCR and SCR thresholds for?
So you alluded earlier to schemes of arrangement, and it seems to me this case was all about the judge's discretion and exercising discretion. Would you say is going to be different because of exercising discretion? I'm just wondering, are you familiar with other forms of procedure where there's a similar discretion that the judge might have that's been looked at or was looked at in this case in a sort of comparison? I mean, I was thinking of schemes as well before you said it, because, you know, we all remember the days of solvency going through, and then all of a sudden, you know, eventually
Yes.
Mm.
the US objectors got their way and
Yeah.
managed to object to something. And that was quite similar, it seems to me. You know, they were basically policyholders saying, what's the policyholder's expectation?
Yeah.
We bought a policy, we expect to have this policy.
Yeah.
And that falls within your second
Yes.
rationale there. So it seems to me, you know, schemes might fall into the category, but I just wondered if you're aware of others, you know, discretionality. It's all about good discretion.
Yeah, I've not anything springing to mind, unless anyone else, any of the other lawyers in the room got anything else jumping out at them. But it was the schemes parallel that I really sensed, because I felt, oh, well, this is starting to feel like we've been here before. And in this case, then, where does it take us? Because what I would have said for the Part 7 process particularly, we have quite a robust framework already in place, probably more so than you would have had with this scheme.
Have you or anybody else in the room had any feedback from PRA as to what they think of this?
We hoped they would be.
They were supposed to. But decided.
They said anything if they were.
Yeah, that's true.
So, we worked with one of the insurers, but we had a conversation with someone who has good insight into the PRA. I'll let people think about who that might be, without naming names. The observation was that probably the view, well, obviously surprise, and a sense that maybe the regulators are going to have to go an extra mile
Yeah.
now. That just simply going no objection isn't good enough.
Yeah.
They probably need to start thinking about setting out something that explains the risks that they've identified and considered, and deciding were okay in the context of getting them to a no objection.
Yeah.
So that was the observation.
So for the sake of full disclosure, used to work at the regulator. And my assessment would be that is exactly what they will need to do, and that's why I think we're seeing feedback coming through certainly to IEs as to certain aspects of their report that needs to be addressed. He didn't explicitly criticise either the IE in this case or indeed the regulators, but I certainly think there was an implicit criticism of the regulators, and I think they need to be seen to be perhaps framing those reports more in the context of their statutory objectives, and evidencing to the court, as you say, what the process is that they've gone through, and the reason that they've reached the decision that they have. And you know, bear in mind, you know, back in the early noughties, the PRA wasn't putting in, or the FCA was in, a report in every single case. So we're seeing just another step along the process of that relationship between the court and the regulators, and what the court's expectations are of the regulators. And Snowden clearly thinks that everybody was just treating the court like it was a rubber stamp.
So just following on from that point, does this in any way kind of extend the scope of the IRLA and the regulators' review, or does this just put further magnifying glass on what they're doing?
I don't think it does extend the scope of what they do. Anyway, I think perhaps it's writing it down more and perhaps pointing the way a bit more, because their scrutiny is generally quite broad, and they've got a relationship with both parties to the transfer over quite a long period of time. I guess you might say in some of these bigger, more complex headlining transfers, you may find that it's escalated internally, which in turn will mean more scrutiny than perhaps it has been.
What I've seen, and I've seen over time, is more scenarios being considered, and so even though it might not necessarily extend scope, the scenario review
Yeah.
is likely to be more
Yeah.
intense.
And that might impact timing. So even if you think, well, we can go through all that process and we'll get to the same result in the end, you might just need to add in a few extra weeks to your planning, as if it isn't long enough.
One of the things that we come across fairly regularly in legacy business now is that the book that's transferring is really a discontinued book.
Yeah.
And one aspect that hasn't really been considered here, as far as I can see, is the willingness of parties, the crew, to really give the concentrated effort on that book of business compared to Rothsay, which I suppose is then undone because they've got the LPT and the claims handling, so
Well,
the
this was,
concentration is there. But to a certain extent, even big players in the market who have got discontinued books, surely the court must see that there's more focus given by a professional run-off provider whose sole job is to provide service to that discontinued book, than a company, whether it's a Lloyd's syndicate or an insurance reinsurance company, is no longer interested, may not even have the staff or resource with the knowledge or experience for that business anymore.
I think that's a very valid point, and that is perhaps something that you'd be looking for your IE to consider, for example, and I don't think that has ever been a point that has been pulled out and emphasised to a degree, because it hasn't really needed to be.
Well, it'd be very difficult for the crew
To
to
say we're not doing it, but perhaps what the emphasis and the support from the regulators to say, well, actually this sector for this type of business brings advantages for policyholders. It's not just a level playing field, actually. There are some advantages in the process.
And that also goes back to engaging your policyholders early, because you can put those arguments before your policyholders as well. If you get them, if you notify them and you give them sufficient information at an early stage as well, so you may never end up in this situation.
And with regard to the LPT, you said there was no underlying provision, but there's nothing to stop the crew and Rothsay commuting it or cancelling it.
Yeah, exactly. So it's a
So, I mean, it seems pretty short-sighted.
of, yes,
For Snowden to assume that would be there in perpetuity.
yes, yes.
Is Snowden a crew policyholder?
Yeah, I didn't want to.
I don't think he declared that in the judgment.
Yeah. You just, I don't know. In the parts of the judgment that he had waivers in a way from one point to another, and then he says one thing, but then 4 paragraphs later he's sort of watered it down and changed it slightly. It's a difficult judgment to navigate, to be honest, to really pull out exactly what it is he was saying. And I honestly, I do wonder if he just had enough.
I don't know enough about, sorry.
No.
I don't know enough about appeals court processes, but when would the argument supporting the appeal become, is it only on the day kind of thing?
Yeah. Yeah, I think we'll know when be a packed courtroom that day.
Sorry.
Yeah, I guess my question was related to that. Do you have any feel for the likelihood of this getting overturned in the appeal court? And if it does get overturned, what does that mean for the rulings that were made? Do they still have some legs in subsequent Part 7s, or would it change the landscape completely?
I think the changes we'll see from the regulators are probably here to stay, because they've been given as I said, and wasn't it? Yes, slap on the wrist, gently.
Gentle. Yeah.
And also, if this appeal is on the basis of errors of law, that's not going to be sort of on what the PRA should or shouldn't have done. That Snowden actually erred in some his application of some of these factors, and it's a challenging appeal, and I don't know. Let's see if they are indeed successful. But I think we should assume that that's, you know, taking care of. Some of these things are pretty easy to do. It's not challenging for the parties in a Part 7 to do them. It's just being mindful of, well, make sure we've ticked all those boxes and we've addressed those points with the regulator as we go through the process.
But to some extent, if the SCR isn't sufficient and that's getting thrown out, then what's the point of the SCR?
Well, this is my coach and horses point. What's it there for? Is the judge I mean, maybe that's one of the points that they're going to raise. I mean, you know, the SCR is there. That's the framework that we've got. Is he saying it's not adequate?
But the PRA has never really accepted that SCR is appropriate for RAR
In any event, yeah.
That they're looking to project to ultimate.
Yeah.
They're looking for the parties to build that in, or looking for the
Yeah.
IE
To build it in,
that
yeah,
to his or her review.
yeah. And which he,
The SCR, I think, it isn't pulling the rug from underneath the PRA, it's actually telling the PRA that what they're doing is probably correct.
Mm.
So in the appeals process, the two parties will be the appellant and the defendant will be the court itself? Or will they try and find some body of objecting?
Well, it will
policy
be
holders?
in the matter. I think it will just be in the matter of. So effectively, yeah, they'll revisit
Will
it.
the judge know
Yeah.
his decision on
Yeah.
trials?
Yeah.
I mean, in some ways, it would be interesting. I don't think it's going to happen. It would be interesting if you had the PRA intervening,
Well,
for
that's what I'm
example.
wondering, whether the court will want the PRA to make any comment.
Yeah, but I haven't heard anything about that. But I think it would be interesting to see where the PRA see their role following that judgment. But I don't think that's going to happen.
And I believe there are and continue to be a group of objecting policyholders, active objecting policyholders. And so let's watch this space in terms of what they do.
I suppose the proof could carve them out potentially.
That sets a dangerous precedent
It does.
as well. Yeah. Yeah.
I'd be interested to hear your view, maybe a bit mischievous, that if this was the same fact pattern, but it was a Brexit transfer, and so therefore there was a different kind of low policyholder lens and maybe a different commercial rationale, but it was moving
Yeah.
to a third party like Rothschild. What's your kind of view on what view Snowden and the court may have taken in that scenario?
Well, he would have had, in that case, it would have been very difficult for him to not approve the transfer if it was a Brexit related, because you're then in a position where arguably the policyholders were not going to be in a position to get paid unless the transferee's jurisdiction was going to permit it. So he could have turned all of those factors, yes, relevant, but actually most important thing is they've got an entity that can pay them after a hard Brexit. Even though most jurisdictions have now put in place some sort of mechanism to permit payment. But
So it really does go up and down depending on circumstances.
yeah, yeah. And in this case, he was just clearly very persuaded by this bunch of individuals and the fact that they'd chosen the proof.
If you were advising the crew now, would you recommend that they go for appeal?
Yeah. It's a lot of money at stake. Cost of the appeal in the grand scheme of things. And they'd spent quite enough already.
In terms of the impact of an appeal court upholding the decision, which by implication might mean upholding all the criteria that have gone into making that
Yes.
decision, and the fetters that might put on both the proof of future activity
Yeah.
and no doubt other future activity.
Yeah.
That's-
Well, they get clarity, and if they're locked in effectively anyway. And Rothsay certainly also has a probably a bigger motive for pursuing an appeal. As I say, and the fees will be a drop in the ocean compared to everything else. So in a way, what have they got to lose? the challenge is finding the hook. I think that they go on because they can't go on discretion, so they've chosen error of law.
Which is a high bar.
A very high bar. And hope they never get Snowden on another transfer again.
Yeah. The case will be full.
Yeah. Yeah.
Although I think he does quite a few of them.
He does, yeah.
Is this decision a good thing? I mean, I know not velocity perhaps, but in terms of a wake-up call, and you said, well, maybe a bit of complacence.
Yeah.
And one of the reasons I say that is I was talking to someone from the Stock some events around the States today, who's talking about getting the rules changed in Oklahoma so they can do a part 7 transfer in Oklahoma. He said they were actually using this as a sort of argument with the commissioner over there, basically saying, look, the system works. You've actually got, it's not just a rubber stamp, it works. This just proves it's not a scam, it's not a scheme. The whole thing works, and this is a good example of why you should have this procedure in your state.
And why you have the court as the ultimate arbiter.
Yeah.
Yeah.
It's quite interesting how someone who would benefit from lots of transfers saying actually it's a good thing.
Yeah.
It's a wake-up call.
Yes.
It's supposed to be to address the issues you're talking about.
Yeah. Yeah, no, I would agree with that. It's just, I think for me, personally, there are just some of the factors that he focused on I just fundamentally don't agree with in this case. But in terms of the wake-up call, everybody needs to stop just going through the motions of a Part 7 in the way I think we've become accustomed to doing, then yes, that is no bad thing. And I'd say that also for the regulators, for whom I think it is also a bit of a process, or has to have become a bit of a process.
It's a very painful process, very long drawn out process.
Yes, and unnecessarily so also. And if you go through that very long drawn out process and end up with this, something's broken.
Was there any? I mean, it feels like this must have struck through a whole load of precedents on previous transactions. But did Prue not come up with that argument saying, well, if you're talking about stronger balance sheet to weaker balance sheet, then how did these ever get through the same process?
They did challenge him on quite a few of the points, because it was Rob Purves was representing. Is he representing the FCA? I think. I can't recall. Sorry. So Rob Purves was formerly of the regulator as well. Between him and Martin Moore, they made some. I was reading the judgment, and each time one of them made a point, but Lord Snowden, what about? I was sort of ticking, going yes. And to be honest, he was just having none of it. For whatever reason, this was the one he wasn't going to turn on. But
being a proof policy vote.
yeah.
At least he's alive with his decision.
No, the sort of balance sheet and the group capital support is I think one that they did disagree, that they both disagreed with. But he used various words, but it was, basically certain for the Prue and relatively uncertain for Rothway. But nobody appeared to really challenging on that where I'm saying, but it's, it's Blackstone and GIC and whatever the American Massachusetts. They're not, fly-by-nights, pillage the company, take all the money out and run away after 3 years. That's not, it's not what any of the three of those shareholders are doing. It was an odd conclusion for him to make.
This is more of an observation, but I'm interested in your thoughts, but what feels odd to me is this has come out with an annuity company as opposed to a unit-linked company where it's not just about, with the unit-linked company, it's not just about capital, it's about much more about ongoing service, and the outcomes of the policyholder are much more variable, subject to how well the underlying life company performs.
But yeah.
Whereas here, you've got a very fixed
It's just
outcome,
pay.
it's just
Yeah.
as long as you're,
Yeah.
enough solvency. So, I don't know, do you think there'll be more challenge on some of the unit-linked type transactions where you've got, even more importance as to who the new...
Well, this Canada Life one was unit linked, and they distinguished it in that case, but they distinguished it on a number of the factors, not just that one.
And it was a different judge.
And it was a different judge. Yeah. It was also Martin Moore, so he was well briefed on how he needed to be steering the judge to get a more positive result in that case. But the transcript's not yet available.
Do you know what role statutory compensation played in this case? Sorry, I'm a non-life guy, I'm a life guy, but I thought life policies were...
FSCS protection, yeah.
Yes.
Yeah.
Because in theory, if you've got an annuity that's a fixed sum every year, your company fails, it pays for the FSCS.
Yeah.
So you don't know what...
Don't think it was referred to in the judgment. Not that I can recall anyway.
Sounds a bit odd, isn't it?
Yeah. Yep.
Were any of the factors that you referred to killer factors, or were they just a combination of factors and thus on balance he went against it? Or was it, that was a sort of cynical, it's just not going to happen on the grounds of that alone? So I know it wasn't characterised in that way, but did you get the sense that any of the factors were absolute killers?
No.
I think the thing that was interesting was that the weight that he gave to the policyholder opposition, which encompassed those factors. So they were unhappy because of X, Y, and Z. So I think the kind of culmination of that was interesting.
Yeah, and that's what I said, because it did read to me as if he was almost trying to find a hook. You know, this whole, and I looked at this website and I looked at this policyholder literature, and he went through everything to try and say they had a reasonable expectation that they wouldn't be transferred, and he couldn't meet that hurdle. So he pulled in all the other factors to say, well, my discretion and I don't like it. In the end, so it did, he just didn't like it, and whether they were particularly impressive in their personal appearances or he was an impacted policyholder. Yeah, I don't know. But there wasn't any one, and I think we can't say it. Oh well, it was just because it was annuity business, and I think initially maybe people thought, well, we can distinguish it on that. But it's when you start to look at those factors and you realise, well, they can be applied to lots of parties in lots of situations.
More questions? If not, we show our appreciation for the presenters.